Hello friends, I am Dr. Vikas Agrawal, Assistant Professor, School of Law, Dr. Hari Singh Gaur Vishwavidyalaya, Sagar, with an interesting and learning episode on the important unit of the Code of Criminal Procedure 1973. Let us start our episode while taking a look at what we are going to learn today. Today we are going to learn about Introduction to the Code of Criminal Procedure 1973, classification of offences, sentences which the criminal courts may pass, trial procedure, and at the last, conclusion. The criminal law is divided in wider sense in two parts, that is substantive criminal law and procedural criminal law. Substantive criminal law defines offences and prescribes punishments for the same, while the procedural criminal law administers the substantive law. Indian Penal Code 1860 together with all the other special enactments constitute the substantive criminal law, while the procedural criminal law is contained in the Code of Criminal Procedure, which we call in short CrPC. The procedural law has been designed to look after the administration and enforcement of the substantive criminal law. In the absence of procedural law, the substantive law would be almost worthless, because without the enforcement mechanism, the threat of punishment held out to the lawbreakers would remain empty in practice. CrPC provides machinery for the detection of crime, apprehension of suspected criminals, investigation of the offences, collection of the evidences, trials of the offences, determination of the guilt or innocence of the accused, appeal against the judgment of conviction or acquittal, and at the same time it ensures the fair trial to the accused. In addition to that, the code also deals with prevention of offences, maintenance to wives, children and parents, and public nuisance. After getting a brief introduction to the Code of Criminal Procedure 1973, let's move to the second important module, in which we are going to discuss about classification of offences. So let's discuss it one by one. For the purposes of the Code of Criminal Procedure, the offences are divided into bailable and non-bailable offences, and the other division is cognizable and non-cognizable offences. We will discuss these offences one by one. First, we will discuss bailable and non-bailable offences. The definition of bailable offence and non-bailable offence is given in section 2 clause A of the code, which is as follows. Bailable offence means an offence which is shown as bailable in the first schedule of the CrPC or which is made bailable by any other law for the time being in force, and non-bailable offence means any other offence. However, the above definition is not clear and does not give a fair idea about the nature of bailable and non-bailable offences. We can discuss it further. Bail means the temporary release of the accused from the custody of the officers of law, on the condition that whenever he will be required, he will produce himself before the authority of law. Bailable offences are those offences in which bail can be claimed as a matter of right, as it is provided in section 436 of the code. The officer in charge of the police station or the court is bound to release the accused on bail, provided he is ready to execute the bail bond. An offence which is not bailable is called non-bailable offence. In case of non-bailable offences, bail cannot be claimed as a matter of right. In these offences, bail can be granted at the discretion of the court or the officer in charge of the police station, as it is provided in section 437 of the code. Whether an offence is bailable or not is to be determined according to the first schedule of the CrPC, as definition given in section 2 clause A provides. As a general rule, all the serious offences have been made non-bailable and less serious offences have been made bailable. Apart from the first schedule of the CrPC, the offences are made as bailable or non-bailable under the various other special laws such as Arms Act, SC/ST Prevention of Atrocities Act, etc. If the offences are defined in the special law, then as a general rule, that special law provides the nature of the offence also, that is bailable or non-bailable. But if nothing in this regard is provided in that special law, then the second part of the first schedule of the CrPC is applicable, which provides that if the offence is punishable with death penalty, life imprisonment or imprisonment for more than 3 years, then it will be non-bailable offences, and if the offence is punishable with imprisonment for less than 3 years, then it will be bailable offence. Now we come to the other classification of offence, that is cognizable offence and non-cognizable offence. From the point of the police officer's power to arrest with or without warrant, offences are divided into cognizable or non-cognizable offence. The term cognizable offence is defined in section 2 clause C, which reads as follows. Cognizable offence means an offence for which, and cognizable case means a case in which police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. And the term non-cognizable offence is defined in section 2 clause L of the CrPC, which reads as follows. Non-cognizable offence means an offence for which, and non-cognizable case means a case in which a police officer has no authority to arrest without warrant. As the definition says that cognizable offences are those offences in which police officer can arrest without warrant, and in case of non-cognizable offences, police officer has no power to make arrest without warrant. The offences in which an immediate and speedy action is required are made cognizable. We can also say that cognizable offences are treated to be serious offences. As a general rule, seriousness is judged according to the punishment provided for the offence, and the offences punishable with imprisonment for less than 3 years are treated to be less serious and consequently non-cognizable offence. However, there are certain exceptions to this general rule. There are offences which are punishable with imprisonment of less than 3 years, even then they are cognizable. For example, the offences under section 143, section 147 and section 160 of the Indian Penal Code. The reason is that a prompt action is required in these offences. At the same time, there are offences which are punishable with imprisonment for more than 3 years, but they are non-cognizable. As for example, the offence under section 211 and section 494 of the Indian Penal Code, because they do not affect the society promptly and hence no prompt action is required. Apart from the first schedule of the CrPC, the offences are made as cognizable or non-cognizable under various other special laws, as for example Arms Act, Prevention of Corruption Act, etc. But if a special law, while creating an offence, does not specify whether the offence is cognizable or non-cognizable, then the question is to be determined with reference to the second part of the first schedule of the CrPC. It provides that if the offence under a special law is punishable with death, imprisonment for life or imprisonment for more than 3 years, then it will be cognizable, and if that offence is punishable with imprisonment for less than 3 years, then it will be non-cognizable. Another difference between cognizable offence and non-cognizable offence is that a police officer cannot investigate a case relating to non-cognizable offence without the orders of the magistrate, as it is provided in section 155 subsection 2 of the code. However, if the information reveals the commission of cognizable as well as non-cognizable offence, then the whole case shall be treated to be cognizable case, and the police officer can investigate the entire case without the orders of the magistrate. So friends, it was all about the basic approach towards the classification of offence. But before moving to our next module, in which we are going to learn about sentences which the criminal courts may pass, I would like to suggest you the important website link, that is www.cec.nic.in. If you have missed any lectures or content, you may log on to this website for full lectures, e-content, LOR, assignments and many more. Hope it will add on to your learning. Sentence is the punishment which the criminal court imposes when it finds the accused guilty of an offence with which he is charged. The sentencing power of the criminal courts are given under chapter 3rd of the CrPC, which can be discussed under the following heads. Sentences which the high courts and the sessions judges may pass. The sentencing power of high courts, sessions judges, additional sessions judges and assistant sessions judges is given under section 28 of the code. Section 28 subsection 1 provides that a high court may pass any sentence authorized by law. What are the sentences authorized by law is given under section 53 of the Indian Penal Code. Section 28 subsection 2 provides that a sessions judge, additional sessions judge may pass any sentence authorized by law, but any sentence of death passed by any such judge shall be subject to the confirmation by the High Court. The procedure with regard to the confirmation of death sentence is given under chapter 28 of the Code of Criminal Procedure. Section 28 subsection 3 provides that an assistant sessions judge may pass any sentence authorized by law except a sentence of death, imprisonment for life, or of imprisonment for a term exceeding 10 years. In the case of R. Chakrabarti versus State of MP, it was observed that in judging the adequacy of the sentence, the nature of the offence, the circumstances of its commission, the age and character of the offender, injury to the individual and to the society, effect of the punishment on the offender, etc., are some of the many factors which should be ordinarily taken into consideration by the courts. In the case of Bachan Singh versus State of Punjab, it was held that in India death penalty is constitutionally valid, though limited to rarest of rare cases. It is an exceptional punishment to be resorted to for reasons to be recorded under section 354 subsection 3 of the code. With regard to section 28, the case of Gopal Godse Vinayak versus State of Maharashtra is also an important one, in which it was held that the imprisonment for life must be treated as imprisonment for the whole of the remaining period of the convict's natural life, unless commuted or remitted by the appropriate authority. Now come to sentences which the magistrates may pass. The sentences which the Chief Judicial Magistrate, Judicial Magistrate First Class and Judicial Magistrate Second Class and Metropolitan Magistrate may pass are given under section 29 of the code. Section 29 subsection 1 provides that the court of a Chief Judicial Magistrate may pass any sentence authorized by the law except a sentence of death, imprisonment for life, or of imprisonment for a term exceeding 7 years. However, it is needed to be mentioned that the maximum amount of fine which a CJM can impose is not mentioned in this provision. It means that there is no upper limit of fine which can be imposed by the CJM. However, section 63 of the Indian Penal Code is relevant here, which provides that where no sum is expressed to which a fine may extend, the amount of fine to which the offender is liable is unlimited but shall not be excessive. Section 29 subsection 2 provides that a court of magistrate of the first class may pass a sentence of imprisonment for a term not exceeding 3 years or a fine not exceeding 10,000 rupees or of both. Section 29 subsection 3 provides that a court of magistrate of the second class may pass a sentence of imprisonment for a term not exceeding 1 year or a fine not exceeding 5,000 rupees or of both. Section 29 subsection 4 provides that the court of a Chief Metropolitan Magistrate shall have the powers of court of a Chief Judicial Magistrate, and a Metropolitan Magistrate shall have the powers of Judicial Magistrate First Class. Here it is important to note that the sentencing power of the magistrates does not affect their power to conduct the trial. Any magistrate may try such cases where for a punishment more than what he can award is prescribed, but in such a case he cannot award a punishment more than what he is empowered to. However, if he feels that the accused deserves a more severe punishment than it is within his power to give, he can take recourse to section 325 and forward the accused to CJM. Now we come to sentence of imprisonment in default of payment of fine. Section 30 of the code empowers the magistrate to impose an additional term of imprisonment in default of payment of fine. If the sentence of imprisonment and fine is imposed on the convicted person and the convicted person makes a default in the payment of fine, then magistrate is empowered to impose an additional term of imprisonment for such default. However, proviso to section 30 subsection 1 imposes following restrictions on that power of the magistrate. The first one is this term of imprisonment shall not be in excess of the power of the magistrate given under section 29. And the second one is this term shall not exceed 1/4 of the term of imprisonment which the magistrate is competent to inflict. Another limitation in this regard is given in section 65 of the Indian Penal Code, which provides that the term for which the court directs the offender to be imprisoned in default of payment of fine shall not exceed 1/4 of the term of imprisonment which is the maximum fixed for the offence, if the offence be punishable with imprisonment as well as fine. Dear friends, before I move to our fourth and last module, I would like to recap what we have learned till now. In the first module, we have learned about the introduction to the Criminal Procedure Code, then classification of offences, in which we have discussed in detail about bailable and non-bailable offences and cognizable and non-cognizable offences. Then in the third module, we have discussed in detail about sentences which criminal courts may pass, in which we have covered aspects of sentences which high courts and sessions judges may pass, sentences which magistrates may pass, and sentence of imprisonment in default of fine. Hope it's all interesting in learning lecture time with me. Now let's move to the last module, that is about trial procedure. The word trial is not defined anywhere in the code. However, we can say that trial is the judicial adjudication of a person's guilt or innocence. Under the CrPC, criminal trials have been given in chapter 18th of the code, which have been categorized into 4 divisions called trial before court of session, trial of warrant cases, trial of summons cases, and last one, summary trial. The first one, that is sessions trial, is conducted by the court of sessions judge only in those offences which are exclusively triable by sessions court. The sessions court will take the cognizance of the case and conducts the trial when the case is committed by the magistrate to it under section 193 of the code. Because as a general rule, all the cases are first filed before the court of magistrate. And if the magistrate finds that the case is exclusively triable by sessions court, then he will commit the case under section 193. However, there are certain exceptions to this general rule in which sessions court can take the direct cognizance of the case. Second type of trial is warrant trial. A warrant trial is conducted in warrant cases. A warrant case relates to an offence punishable with death penalty, imprisonment for life, or imprisonment for a term exceeding 2 years. Warrant trial is further divided in 2 parts. First one, warrant trial of cases instituted on police report, and the other one, warrant trial of cases instituted on complaint. The third type of trial is summons trial. A summons trial is conducted only in summons cases. A summons case means a case relating to an offence punishable with imprisonment not exceeding 2 years. In respect of summons cases, there is an additional important fact to be noted down. That is, in summons cases, there is no need to frame the formal charges. The court gives the substance of the accusation, which is called the notice, to the accused when the accused appears before the court or brought before the court, and then the trial proceeds. Fourth type of trial is summary trial. This trial can be conducted by CJM, Metropolitan Magistrate, or JMFC if especially empowered by the High Court. This trial is generally conducted in less serious offences, such as offences punishable with imprisonment not exceeding 2 years, or in case of offence of theft where the value of the property does not exceed 2000 rupees, and in all the other cases which are mentioned in section 260 of the CrPC. The High Court may also empower judicial magistrate of the second class to conduct the summary trial in case of offences punishable with fine only or with imprisonment not exceeding 6 months. It is also important to note here that in a summary trial, no sentence of imprisonment for a term exceeding 3 months can be passed in any conviction. Now we will discuss the stage-wise process in a criminal trial. The common features of all the 4 of aforementioned trials may be broadly divided into the following distinct stages. The first one, framing of charges. Second one, recording of prosecution evidence. Third, examination of the accused. Fourth, evidence for the defense. Fifth, court witness. Next, final argument, and the last one, judgment of conviction or acquittal. Now we will discuss all these stages one by one. The first one, framing of charge or giving of notice. The trial begins with the framing of charges. When the accused appears or brought before the court, then the court considers the evidences to find out whether or not a prima facie case against the accused is made out. If upon consideration of the evidences produced, documents submitted, and after prima facie hearing of the prosecution and defense, the court is of the opinion that there are no sufficient grounds for proceeding further, then the accused shall be discharged. On the contrary, in case the material produced before the court raises a grave suspicion on the accused and a prima facie case is made out, then the court shall frame the charges against the accused and proceed with the trial. In the case of Union of India versus Prafulla Kumar, It was held by the Supreme Court that in deciding whether or not a prima facie case, the court cannot act merely as a post office or a mouthpiece of the prosecution. It was also observed that the test to determine a prima facie case against the accused would naturally depend upon the facts of each case, and it is difficult to lay down the rule of universal application. The charge is read and explained to the accused, and the accused shall be asked whether he pleads guilty of the offence charged against him. If he pleads guilty, then the judge shall record the plea and may convict him on such plea of guilt. But if he pleads not guilty, then the further proceedings shall be conducted. Now we come to the second stage of trial, that is recording of prosecution evidence. If the accused does not plead guilty, then the court shall fix a date for the examination of prosecution witnesses. On the date so fixed, the prosecution is asked to examine its witnesses before the court. This is called examination in chief. And then the defense, if it so desires, may cross-examine all the witnesses presented by the prosecution. The evidence of each witness shall be taken down in writing as it is provided in section 276 of the code. The evidences so taken down shall be signed by the judge and shall form the part of the record. Now we come to the third stage of the trial, that is examination of the accused. After the examination of the prosecution witnesses and before the accused is called on for his defense, Section 313 of the code requires the court to question the accused generally on the case for the purpose of enabling the accused personally to explain any circumstances appearing in evidence against him. This section requires the court to question the accused properly and fairly so that it is brought home to the accused in clear words the exact case that the accused will have to meet, and thereby an opportunity is given to the accused to explain any such point. Now we come to the fourth stage of the criminal trial, that is evidence for defense. After the prosecution evidence and the examination of the accused shall be called upon to enter on his defense and adduce any evidence he may have in support thereof. This provision is intended to protect the interest of the accused person. If the accused applies for the issue of process for compelling the attendance of any witness or for the production of any document or thing, the court shall issue such process unless the court considers that application to be vexatious or for delaying the ends of justice. Section 315 of the code provides that the accused himself is a competent witness and he can give evidence on oath in disproof of the charges made against him. The next stage of the criminal trial is court witness. In a criminal case, the fate of the proceeding cannot always be left entirely in the hands of the parties. The court has also a duty to see that essential questions are not left unanswered. The provisions of section 311 of the code are intended to serve this purpose. This section provides that any court may at any stage summon any person as a witness or examine any person in attendance though not summoned as a witness, or recall and re-examine any person already examined, and the court shall summon and re-examine or recall and re-examine any such person if his evidence appears to it to be essential to the just decision of the case. The next stage of the criminal trial is final arguments. When the examination of the witnesses for defense is complete, the prosecutor shall sum up his case and the accused or his pleader shall be entitled to reply, provided that where any point of law is raised by the accused or his pleader, the prosecution may, with the permission of the judge, make his submissions with regard to such point of law. Next and last stage of the criminal trial is judgment of conviction or acquittal. After hearing the final arguments, the court shall give the judgment in the case and the accused either be convicted or acquitted. If the court convicts the accused person, it may release the offender after admonition or on probation of good conduct, in accordance with the provisions of section 360 of the code or under the Probation of Offenders Act 1958. In case the offender is not so released, the court shall hear him on the question of sentence and then pass a sentence on him according to law. The object of hearing the accused on the question of sentence is to acquaint the court with the social and personal data of the offender and thereby to enable the court to decide as to the proper sentence and the method of dealing with the offender after his conviction. At the last, we can say that the Code of Criminal Procedure 1973 is an important legislation which provides for the classification of offences, sentencing power of the criminal courts, lodging of FIR or filing of complaint, investigation of the offences, filing of charge sheet, conduction of trial, the procedure with regard to bail and appeal, etc. The substantive portion of criminal law is incomplete without this procedural legislation. With all this information, here we come to the end of today's topic of discussion. Do revise the points what we have discussed today with mentioned references for more understanding. This is Dr. Vikas Agrawal logging out from today's discussion. I will be back with you with few more lectures in this series. For more information relating to this topic, MCQs, LORs, you can log on to our website, that is www.cec.nic.in. Till then, keep studying, good luck and goodbye.